Good evening. It's a judgment that has empowered the citizens of India like never before. Right to privacy is a fundamental right under the Constitution. For the very first time, the Supreme Court has laid that out clearly in a landmark ruling that affects the lives of all Indians, all of us. The judgment today was unanimous. 9 judges of the top court ruling that the right to privacy is an intrinsic part of right to life and personal liberty under Article 21. The order, a huge victory for those who've tirelessly fought against the intrusion of the state into our daily lives. It's also a big blow to the government, which had argued in court that the right to privacy was not a fundamental right. It is a judgment that may not only have a bearing on the Aadhaar issue, but also on Section 377, which criminalises homosexuality, and on other issues, for instance, like the state barging into your home to see if you've stored beef in the fridge. In a huge boost to the LGBT community, the court said, for example, that one's sexual orientation is undoubtedly an attribute of privacy. Here are the highlights of this landmark ruling today.
The people of India have today been empowered with these words. The right to privacy is protected as an intrinsic part of the right to life and personal liberty. Today's Supreme Court verdict describes privacy as the constitutional core of human dignity and an inalienable right. There were 6 orders by the 9-judge bench, but all concurring. The verdict took apart key arguments of the government against making right to privacy a fundamental right. It says the government's argument that the right to privacy is an elitist construct is unsustainable, and that this betrays a misunderstanding of the constitutional position. Further on, the verdict says the poor, the AG talks about today, have cell phones and would come forward to press the fundamental right of privacy. We see no antipathy whatsoever between the rich and the poor in this context. It seems to us that this argument is made through the prism of the Aadhaar. This argument again does not impress us and is rejected. Just 2 days after celebrating a Supreme Court verdict against triple talaq, today the law minister found himself doing verbal calisthenics, saying the government had always said privacy was a fundamental right.
The government has been consistently of the view the right to privacy should be a fundamental right.
However, crucially on the subject of personal data like Aadhaar, the order leaves it to the government to create a robust regime for data protection. That would be a careful and sensitive balance between individual interests and legitimate concerns of the state.
You must also note that it's not that you can do whatever you like. It's not an unfettered right to privacy. The Supreme Court has made it very clear, yes, you have a fundamental right to privacy, but the state can impose restrictions in public interest.
With the 9-judge constitution bench ruling that privacy is a fundamental right, soon another bench will decide whether collection of an individual's private data through Aadhaar scheme violates privacy or not.
Vidya Vaidyanathan, Chetan Bhattacharjee for NDTV.
Well, joining us tonight on Left, Right and Centre, we're joined by Law Minister Ravi Shankar Prasad this evening. Mr. Prasad, thank you for speaking to us on what is a very big day. Let me first ask you what your overall reading of this judgment is and the implications it has for the citizens of this country, because it's not something that's only limited to, say, Aadhaar. This is a judgment, sir, that could impact very different aspects of all our lives.
I think that is the right way to approach it. It's a great day because we had a judgment in the 50s and the 60s of 8th bench and 6th bench which held to the contrary, that it is not a fundamental right. And the Supreme Court over the years rightly took the view that Indian democracy is a robust democracy. Therefore, right to privacy must be held to be a part of fundamental right. What is more important, which Mr. Datar I heard him on your channel, the Supreme Court has also held that though it is a fundamental right, flows from Article 21 and other fundamental rights, it is not an absolute right. It is subject to reasonable restrictions as other fundamental rights are. And the second is the factual implications is required to be adjudicated from case to case basis. Therefore, a very robust mechanism of privacy being elevated to the concept of a fundamental right has been laid down. Nidhi, I would like to clarify one thing, because your initial anchor who was giving a report commented about me that I am taking a contrary position. It is not. The argument of the Attorney General has been noted in the Supreme Court itself at page 193, where he has stated it is not an independent fundamental right, but part of right to life and other subspecies with reasonable restrictions. And Mr. Arun Jaitley, Finance Minister, on 16th of March 2016, while moving the Aadhaar Act in Rajya Sabha, categorically stated that we do recognize privacy as a fundamental right flowing from Article 21. It is also subject to reasonable restrictions.
But Mr. Prasad, Mr.
The
Mr.
government
Prasad,
position has
with
been clearly outlined.
with respect, that is not the position the government actually took in court. And I quote to you what Mr. Venugopal said in the Supreme Court, and which the court actually struck down with a specific reference to this. He said a vague and amorphous right can't be held as a fundamental right. The right to privacy argument is elitist. This was the government's position in the court. You're right about what Mr. Arun Jaitley said, but that's not the position he took in court.
I would only tell you, Nidhi, that kindly read page 193 of the judgment. I am having a copy of the judgment, where all the arguments of Mr. Venugopal has been quoted. What Mr. Venugopal has argued, as to what the petitioners are arguing, that right to privacy is an stand-alone fundamental right. Okay. He said, no, it is not a stand-alone. It flows from the existing fundamental right, a part of right to life with dignity and other fundamental rights. And I would, great respect to you, say that that argument has been upheld. Let me put it differently. Let us forget about the perception. Now it is a judgment, it is binding. Okay? And let me elevate this debate to a different level.
Mr. Prasad,
now privacy has been read as ingrained.
I just want to though ask you, sir, sorry to interrupt.
All right, go
but
ahead.
The previous Attorney General, before Mr. Venugopal, also took a position in the Supreme Court that right to privacy is not a fundamental right. He did it once in 2015, where he said that it's not a fundamental right, it can't be invoked to scrap Aadhaar, and that the constitution makers did not intend to make privacy a fundamental right. Mr. Rohatgi argued in May of this year that one cannot have an absolute right over his or her body. Mr. Rohatgi, who is coming on the program later today, has reiterated that. He feels that the court has overstepped, that it is a case of judicial overreach, what has happened today. Mr. Prasad, how can you say that the government took a position that right to privacy is a fundamental right, sir?
First of all, you don't pitch me against my former Attorney General. That is not fair. Okay? He said it at the stage of an interlocutory applications about interim orders, and he did a good job. Okay? Nidhi, your viewers need to know that we have saved 57,000 crores of the poor through DBT using Aadhaar and mobile and Chandan account, which used to be pocketed by middlemen or fictitious claimants. Poor are happy, but that is beside the point. What is important is the firm articulation of the view was given by Mr. Arun Jaitley, the Finance Minister, when a specific query was asked of him as to what is the stand of the government as far as right to privacy is concerned.
But that was
and
not
what
in
he
court.
said on 16th of
But that
March,
was not in
I have
court.
articulated.
That was not in
Just
court. In court, the government took a different position.
In court, Nidhi, please, I just told you what Mr. Venugopal argued. Read at page 193. It was very clearly stated, we don't agree with the view that it is an absolute right, independent fundamental right. But this right is ingrained in the existing fundamental rights, which we respect and subject to the reasonable restriction it is. But today, let us not quibble about the argument. Today, there is a judgment. And as far as Aadhaar is concerned, Aadhaar is to be adjudicated separately. But our view is very clear that we have got a law sanctioning a legislative approval to Aadhaar with due regard to privacy, section 26 to section 33. And I, as an IT Minister of India, Nidhi and Law Minister, cannot disclose my own biometrics or iris to anyone for unauthorized use. Today, the UN and the World Bank all are appreciating this great delivery.
Well, as
but
you
we'll
said,
argue ourselves in the court.
And as you
That's
said,
one thing
it's something that the court has to look at separately.
Yes.
So the Aadhaar issue is something that will be watched closely. Do you think also, Mr. Prasad, though, that some of the other things that the court said today could actually give a cue to Parliament to perhaps legislate? For instance, on section 377, the judges were very unequivocal in what they felt on the issue of homosexuality, saying discrimination based on sexual orientation is offensive to the dignity of an individual. There should be equal protection of every individual individual without discrimination, that sexual orientation is an essential component of identity. Is this a very clear message from the top court today that Parliament could actually take a cue from and maybe initiate a change on that law?
I think that aspect requires to be examined. I share with you that some of the judges have been very firm, but not all the judges. Okay? Therefore, to read it as in, with due regard to the rights of lesbian and gay, they have been agitating and they may have a point also. But since you are reading it in today's judgment as a part of a dictum, that matters, I'm afraid, requires some examination. There are certain other pending issues, and the Parliament will have to take an independent call regardless of this judgment. They have been agitating. But today is not the occasion for me to speak authoritatively as to what is required to be done, because that matter requires some examination.
There is another important comment made, another important observation made, where the judgment talks about life being precious in itself, that the duty of the state is to safeguard the ability of people to take decisions, the autonomy of the individual, and not to dictate those decisions. What do you think of that, Mr. Prasad, at a time when people have been unhappy about, say, being told what they should eat, whether beef should be eaten or not eaten, whether homes should be raided by the police over whether beef is stored in a fridge and so on. These seem to be very strong words coming from the Supreme Court today.
First of all, since you have asked me this question, Nidhi, let me make it very clear as a senior minister of this government. We are not in the business of determining the food habit of Indians. We celebrate the plurality and diversity of India. Yes, there are a view in the constitution itself, a big majority of people respect, worship cows. Others have the different taste. And that diversity needs to be explained and also understood. The second part is concerned, yes, we are a part of the robust democracy. And since I'm on NDTV today, I need to say it with some degree of pride, that this government is led by Narendra Modi, Sushma Swaraj, Rajnath Singh, Arun Jaitley, Ravi, Shankar, Prasad, who have fought in the emergency for 3 freedom: individual freedom, media freedom, and independence of judiciary. And don't forget this, Nidhi, allow me to say that there was an argument by the then Attorney General of the Congress government that if a person is killed in emergency, he has no remedy. That was upheld in ADM Jabalpur.
And that's why the Congress
That is also the record of the fight of civil liberty.
That's why the Congress was. That's why the Congress was voted
out. What is
out.
important today?
But
Nidhi,
Mr. Prasad, let me ask you a final question,
you are
sir.
right today.
I just want to ask you a final question on Aadhaar. And of course, as we said, the court is looking at that matter. How would you address the concerns, though, that people have about privacy issues and Aadhaar? It is still a big concern. Many people, and data has been compromised in the past, and it has been compromised at a large level. It's also been contained. But how would you address those concerns today?
First of all, no data has been pilfered on a large measure. Some people tried to, they have been arrested, police action has been done because of tough law in the Aadhaar law, number one. Number two, Nidhi, I would welcome to have an independent debate with you on Aadhaar. Let me assure the countrymen, the Aadhaar law is safe, secure, and privacy has been given due regard. And we can only release data for national security, and that too approved by a joint secretary decision based upon cogent ground, affirmed by a committee of cabinet secretary, IT secretary and law secretary. What Supreme Court has said in the telephone tapping case. Therefore, and it is a part of good governance. But let me come to the larger issue. And Nidhi, NDTV is watched in many parts of the world. Therefore, it is important for me to convey that. India is emerging as a big digital power. Today, India's digital story of Digital India is being celebrated world over. Many countries are talking about this great success of digital inclusion of the poor and marginalized. What is important for us is to balance the right of the people of privacy and the availability of data. And therefore, we are constituted a committee headed by Justice Sri Krishna, a very eminent retired judge of the Supreme Court, to ensure a proper data safety and security. But let us not do anything which seeks to compromise the emergence of India's digital power, innovation, and other startup movement today, which is becoming a great celebration and success story of India.
All right.
That
well,
is very important to be conveyed.
All right, Mr. Prasad, let's see what the Supreme Court actually does say on the Aadhaar case. Thank you very much for speaking to us tonight. Law Minister Ravi Shankar Prasad there, articulating the government's position on this landmark day, on this day where there has been this big ruling by the Supreme Court. We have a terrific panel joining us in the studio tonight. Former Law Minister Ashwini Kumar, one of the committees that he had set up on this issue actually was specifically referred to by the Supreme Court in its judgment today. Indira Jai Singh, for Senior Supreme Court advocate here in the studio with us, Arima Sundaram, Senior Advocate of the Supreme Court, also joining us, and Jay Panda, Member of Parliament from the BJD, also joining us this evening. Let me ask Mr. Ashwini Kumar first. This is something that you've been so passionate about, and that day is finally here. Interesting what Mr. Ravi Shankar Prasad was saying there. He says the Attorney General made an argument in court that it cannot be an absolute independent right. Do you buy that argument, or do you think that the government's tied itself in some knots?
Well, I think you already put Ravi Shankar Prasad on the mat, and rightly so. I think it's a completely fallacious suggestion to make that the arguments advanced by two Attorney Generals of this government before the Supreme Court was that there's an independent absolute right. It was never anybody's case. It is not the case even of the Supreme Court. Supreme Court has deduced this right from Article 21, and all that has happened in the last couple of years is that in a series of judgments seeking a coalescence between Articles 14, 19 and 21, which has been reaffirmed in this judgment, in R.C. Cooper's case, 11 judges said that the basis of treating fundamental rights as distinct and exhaustive and exclusive is over. They read 14, 19 and 21 together, and that is what the 9 judges have today affirmed, and that is why R.C. Cooper, which was an 11 judges judgment, should have been followed, and the Attorney General should have said that after R.C. Cooper, what we now have is what the Supreme Court has held today. On the contrary, 2 very eminent lawyers who are Attorney Generals and senior most law officers of the government, on instructions, told the apex court in no uncertain terms that privacy is not a fundamental right, and that is borne out by what Mr. Mukul Rohatgi has now stated, that this is an act of judicial overreach. He could not have said this is an act of judicial overreach had this government's position been, or has his position been, that privacy is a fundamental right. And this is what appalled us. This is what shocked me personally, and I remember I wrote a piece in the Hindu at that time saying that this is a completely untenable position. What has today been said authoritatively is the only thing that could have been said consistent with the Supreme Court's own jurisprudence that has evolved over the last couple of years. And as you rightly pointed out, and as the court has rightly pointed out, and this is the core of it, ours is a dignitarian constitution. It is a libertarian constitution, but above all it is a dignitarian constitution, and liberty and freedom and privacy and right to reputation have been read together as advancing the goals of the dignitarian constitution.
I just want to ask Indira Jai Singh, though, to explain to our viewers, when the Supreme Court declares the right to privacy as a fundamental right, what does that actually mean, and what are the reasonable restrictions that can be placed on that? Because the judgment doesn't go into specifics, but does that leave a lot of things open to interpretation?
Okay. Well, first of all, the 2 questions. The first one is, what does it mean when the court says it's a fundamental right? What it means is that any law that the government will enact in future, let's say a data protection law, will also be subject to challenge on the ground that it violates the right to privacy. So let's say there is a so-called privacy law or a data protection law which doesn't actually give you the privacy that you are looking for. That law can also be challenged. This is the significance of saying it's a fundamental right and not just a statutory right. That's the answer to your first question, and that is why we argue that it is not just a statutory right, it's a fundamental right. Because
which means tomorrow, as a citizen, if I feel that my right to privacy is being violated, I can go to court and get remedy.
Not only can you go to court, but if you feel a particular law is violating your right to privacy, you can go to court. Which means whether it's Aadhaar, or whether it's an abortion law, or whether it's a surrogacy law, or whether it's a medical termination of pregnancy law, if you feel there's a violation of your right of privacy or that law itself can be challenged on the ground that it violates the right to privacy. That's the first part of the answer to your question. And I think the second part
On the reasonable restrictions.
the reasonable restrictions. Now, I'm amazed that the law minister said that the court has not located the right as an independent right. Now, the advantage to us of not locating it as a fundamental right is that it then becomes part of the entire Constitution, because it's not located in the right to life itself. It's also, the court says, located in every freedom. So in the right to free speech, in the right to associate, in the right to profession, in the right to work, this is where privacy is located. So it's basically located from birth to death in every aspect of your life. So by saying that it's not located in one article of the Constitution, the court is actually expanding the scope of the right to privacy. So rather than being a disadvantage, it's a big advantage for an ordinary citizen to be told that the right to privacy is everywhere. From the preamble to the last article of the Constitution, you have it.
So, Mr. Sundaram, how does that, fundamentally change the way we can live our lives? I asked Mr. Prasad, for instance, on Section 377, and he was hedging his bets on that one. But it's something that's so huge. In a country that still criminalizes homosexuality, for a number of judges to speak out on that the way that they have, what they've said about the state intruding on our lives and trying to dictate what we do, the decisions we make. These are all issues that are very fundamental to our existence, Mr. Sundaram.
Look, the fact of the matter is that I think it's a judgment which has a lot of fine print which has to be looked into. But the big two takeaways of this judgment are these. Number one, that the Supreme Court of India has gone further than courts elsewhere in the world, including the Supreme Court of the United States and the House of Lords in England, which have refrained from declaring the right to privacy to be a basic human right or equivalent to our fundamental right, and in even recent judgments they have refrained from doing so. Our Supreme Court has taken a very far-reaching step in making such a declaration. The second issue also, the big takeaway is that again, while courts like the United States Supreme Court and English House of Lords have often said that these are legislative functions and to be done by the legislature, and while one of the submissions put forward before the court was it should be done through constitutional amendment, not through a judicial pronouncement, the Indian court has seen fit to read in to the fundamental rights a right to privacy. These are the two big takeaways, and this will directly answer your question. The answer is really here. It was the state's case throughout that there were various manifestations of privacy, aspects of privacy, which could very well fall within one of the fundamental rights, as in Article 21. There could be a manifestation which was also a manifestation of privacy, but would have to be traced to Article 21. But that privacy as a standalone concept, being a concept and not being capable of exactitude, couldn't be given an independent fundamental right status. And therefore you have to look to the articles as standing to see whether that particular aspect which you are complaining about will fall within Article 21. Now the observations made regarding sexual orientation have a big role to play in that, because earlier when the attack was on the ground of discrimination under Article 14, on the ground that a gay or a lesbian was being discriminated against, and therefore perhaps Section 377 was violative, today it takes on a different hue altogether, because the argument can go to the extent of sexual orientation is part of a right to life and liberty as recognized by the court, and if it is a part of life and liberty, the reasonable restriction on it through 377 may be excessive, may not be reasonable, may not be correct. Now, that case is currently pending before the Supreme Court because the curative petition on Article 377 is before the Supreme Court, and I'm sure that the judgment rendered today will have a big role to play
Certainly.
in the deciding of that case.
Jay Panda, what do you think firstly, your initial reaction to this is again an issue you've been writing and speaking on quite extensively, but how do you think, the Aadhaar case may be looked at from here. It's hard to predict what the court will do, and I think it's very important to tell people that this is not a verdict on Aadhaar. This is not a judgment about Aadhaar. That issue is separately being looked at by the Supreme Court. We'll have to wait and see, won't we, Jay, to see how the Supreme Court looks at these reasonable restrictions, within the Constitution then, as far as Aadhaar is concerned.
I have not only been writing extensively about this, I have actually introduced a private member's bill in the Lok Sabha after 1 year of public consultations and a lot of research on this. And I'm very, very thrilled by today's judgment because it mirrors almost exactly the line I have been taking, that privacy ought to be a fundamental right derived from the right to life and liberty, and also that it cannot be absolute. There are certain activists who are insisting on an absolute right of privacy, which is not practical in the 21st century. Because we both voluntarily and involuntarily, we have given a lot of data out to social media sites, apps, and also government agencies and surveillance. So the line I've taken and what the Supreme Court has ruled today is this, that it is a fundamental right, but there have to be certain few narrow exceptions. Now, during the hearings, the Supreme Court was talking about case-to-case exceptions, but I'm glad they have used the phrase narrow tailoring, that is narrowly defined exceptions for things like national security. I want to take a moment to explain this because this is crucial. We should not be able to use national security or anything like that as a sweeping excuse to do surveillance. And so there have to be extremely narrowly defined prima facie causes for any such invasion of privacy to be allowed. But coming to Aadhaar, it's very odd that this became a binary. It became a debate about privacy versus Aadhaar. And of course, privacy goes far beyond Aadhaar. It has to do with our millions of credit card transactions, online digital transactions, usage of smartphones and social media apps. So this goes beyond Aadhaar. But there is a very strong clue in today's judgment. In Justice Chandrachud's words, he has explained that one of the narrow exceptions can be, and I quote, preventing the dissipation of social welfare benefits. And that is precisely what Aadhaar is used for, to deduplicate fake beneficiaries. So I think this will have a big bearing on the other bench of the Supreme Court, which is hearing the Aadhaar case. But as you have rightly pointed out, this goes far beyond Aadhaar, and I think the comments on section 377 are far, far more important as an outcome of what will happen from this ruling today.